Yes, Mr. Pinsky.
My Lord, very hopefully the appellants selectively have indicated to us that the UNHCR does need more time. They concede 15 minutes, which would allow us to continue until 2:35.
All right.
Now, before lunch, I was addressing the point of how impervious off-the-books decision-making is to assurances. And on the reference note, I am just reaching paragraph 6A, Roman numeral 4. It's not an answer, of course, as to remediation by the assurances that individuals transferred would be accepted by the Rwandan authorities before transfer occurs. The Rwandan authorities, including the DJA, may of course find out more information about an individual after transfer. The individual's post-transfer conduct may alter the Rwandan view of his palatability, or Rwanda's external or national security interests may change over time. Nor is it an answer that the government of Rwanda and Secretary of State point to a new digital record-keeping system under the MEDP. That is not only because by definition off-the-books decision-making may not appear at all on such a record-keeping system, but for a further reason that I shall come to in a moment. Now at Roman numeral 4, since the problems with the DGA are not now acknowledged by the government of Rwanda, and since UNHCR was not consulted about or indeed informed of the UK's plans during negotiations over the assurances, none of this has been grappled with in the assurances. On the contrary, the DGIE remains central to the MEDP system as it was envisaged, and indeed essential tools to continue to engage in abusive behaviour remain in the DGA's hands under that system. Some references: the majority of work on case preparation and associated functions will be done by DGIE caseworkers. You have all the references in the list. The DGIE itself will run the digital record keeping system. It will continue to sit on the main decision-making body, the RSDC. And to be clear, it's not just the umbrella security agency that will sit, it's the DGIE itself. The DGIE will still have responsibility, a powerful one, for granting and extending residence permits. The DGIE apparently will run the MEDP complaint system as concerns reception conditions and asylum procedures. And as Mr. Hussain noted yesterday, it will sit on the joint committee to which the monitoring committee reports. If authority were needed for the proposition that one needs to consider which are the key personnel, which is the state entity principally responsible for present or past violations of relevant legal obligations, has there been reform to address any problems or risk that entity poses, and would the role of that entity be addressed by the assurance? If I needed authority for the proposition that those are key questions, I would draw your attention to the case of Chahal. I won't ask you to turn it up, but the references are at paragraph 7A of this list, including the relevant paragraph. So that was a case where the Grand Chamber found it important when assessing the reliability of assurances given by India that the relevant police force was unreformed and unrestructured. I turn now to our second example of how the assurances, as a matter of fact, do not wipe the slate clean, but preserve key and problematic aspects of the existing system. And I'm now at 6B of this references list, the right to be heard. Asylum seekers in Rwanda may currently have only one interview in the asylum process, which is with the DGIE. That remains the position under the MEDP. So they may have further interviews, but nothing is guaranteed. The DGIE interview itself, from UNHCR's evidence, is short, 20 to 30 minutes sometimes, may be directed to points irrelevant to the asylum claim. There is no practice at the DGIE of alerting asylum seekers to potential problems in their claims. They don't have an opportunity to address those. Those are denied by the government of Rwanda. We've also given you references to Lawyers are currently not allowed to attend the DGI interview or any interview that may occur with the eligibility officer or with the RSDC, or any hearing that might occur before Memorandum. The government of Rwanda's own evidence confirms as much. Lawyers can assist asylum seekers behind the scenes in preparing their written asylum applications, but not represent them or participate or attend those events. And it appears that under the MEDP, lawyers will still be excluded at those stages. As I mentioned earlier, there's no hearing before the formal decision-making body, the RSDC, on which the DGI sits, nor is a hearing guaranteed in any internal review that may be conducted by the ministry. So no guaranteed ability to make rules, and that is unaffected on the face of the MOU and nothing like that. The Secretary of State places reliance upon the untested option of the High Court, where lawyers are indeed allowed, according to the Memorandum. The question of whether that is an independent court, an independent judiciary, has been addressed by Mr. Hussain. UNHCR knows that it is unclear what the jurisdiction is of the High Court. The government of Rwanda calls it a judicial review of the earlier decisions. The Secretary of State prefers to a rehearing. Even if it is a rehearing, we don't, of course, know what weight the High Court places, or will place, on the outcomes of an administrative process, so the DGIE, RSDC, Manema, which UNHCR considers to be unfair, unsafe, and unreliable. Finally, closing this part of the submissions on the right to be heard, there is no system for fresh claims. That is, no system by which a person who obtains fresh evidence, which could not earlier reasonably have been obtained, or whose circumstances change while they are in Rwanda, can reopen their case after rejection. This too is not addressed in the Memorandum. And of course, these structural problems, to make a wider point, are not amenable to alteration by resources, and nor can they be addressed by reducing, turning down the tap of transfers. They are, as Mr. Hussain put it, qualitative rather than quantitative problems. I turn now to our third example of how the assurances, as a matter of fact, fail to address key problematic aspects of the current system, and that's cursory decision-making. I'm now at 6C of this reference list. UNHCR considers that the RSDC's non-specialist and rotating, changing composition and its minimal relevant expertise is inimical to reliable or fair RSD decision-making. And of course, the non-specialist and transient composition of the RSDC is not amenable to rectification by assurances, and again, nor is it a quantitative problem addressed by greater resources or by a reduction in the number of transfers. Next, the RSDC considers as many as 40 cases in a single session. UNHCR is unequivocal that this is happening. Cursory reasons. UNHCR notes that decisions both by the RSDC and where there are internal reviews by Manema may lack any reasons or give the most peremptory of reasons. And notably, this remained unchanged 3 months after the MOU was signed and 6 weeks after the plane was due to land on the 14th of June. May I ask your Lordship to turn up? I'm not asking you to turn up much, but this is quite an important one. This is LB35, it's bundle 5, common bundle, tab 109, common documents bundle, not tab 109, page 1800. So this is a Manema refusal dated the 18th of July, and I would just just ask you to look at the last paragraph above the signature. We regret to inform you that the refugee status requested was not granted because you're not meeting eligibility criteria, and the reasons provided during the interview were not pertinent. So those are our examples of why we say there's no clean slate, in fact, under the MEDP. I was going to address you on why that approach is wrong in law, but given time and perhaps a more helpful focus on the facts of the assurances and the current circumstances, I'll simply point, if I may, to the reference to paragraph 7 of our submission and move on to the next factual point. So I'm now at paragraph 8 of our references list, reformer. And we do say this is a particularly stark example of the Divisional Court's failure to reach any conclusions or give any reasons on a key issue. As Mr. Hussain mentioned, the Divisional Court mentions only 5 cases of reformer, but even as to those 5, it is unclear whether it accepted that the events occurred and were prohibited under the Refugee Convention, or whether it thought that they were irrelevant, and if so, why. So, if I could ask you please to turn up again to keep open our list of references, but also to turn up the reformer table in the AS supplementary bundle, which is bundle number 31, at tab 10, electronic pagination 43. This is what Mr. Hussain showed you yesterday. So this is the same table from the Divisional Court, but we simply updated the references so that they cross-refer to the current bundles. There are 3 points I wish to make. There are 3 points that I wish to make concerning reformer. First, contrary to the Secretary of State's suggestion in her skeleton argument, the key facts which give rise to a breach of Article 33(1) of the Refugee Convention are not in dispute, and that can be seen clearly from the right-hand column of the table. On this issue, could I for a moment address, please, a point that was raised by my Lord, the Lord Chief Justice yesterday, and that was about whether any of those cases referred to by UNHCR had a right to reside in the putative third country to which they were being expelled by Rwanda. The answer is no. So the count in the reformer table, UNHCR does not understand any of the individuals in that table who were physically expelled to have had a right to reside in the country to which they were expelled. And I've given you the references. I won't go into a wealth of detail, simply to say the government of Rwanda, in responding to LB2, referred to an additional 4 Syrian cases. And UNHCR thinks that what may have arisen is that one of those may have had, possibly, a right to reside. But in any event, of course, summary expulsion of asylum seekers whose claims have not been decided is not permitted under Article 33(1) of the Refugee Convention. And moreover, there is an analogue to the Ilias duty. And as concerns Article 3, there is the Ilias duty itself, upon an expelling state that has not determined an asylum claim and wishes to remove that person, to investigate the safety of the receiving country, including whether the person does in fact have a right to reside there. That duty, of course, applies to Rwanda as well as the UK. And that is, of course, also by way of an answer to the question raised yesterday by my Lord, the Vice President, concerning what degree of knowledge does the expelling state need to have about the likelihood of change of formant? And the answer is Ilias, in essence. You need to investigate. Now, turning to what appears as 8D in our table, To the extent that there is any dispute worth the name about the Reform Act, there is a legal one. We have given you the list of misunderstandings, and they are various here. I don't think I need to address those in detail. You've got the references there. Our next point is 8E of our references list. Rather than probe the disturbing misapprehensions of the law, or, for example, probe the government of Rwanda's silence concerning reforms under the Israel-Rwanda agreement, the Secretary of State has herself relied upon the government of Rwanda's legally baseless denials of reform, and that appears in the Secretary of State's evidence, her pleadings, and in her CPIN assessment of Rwanda's safety. Fourth point is that the reforms are significant. And here I have a number of sub-points as to significance, which I shall take quite quickly. And this is now paragraph 8G of the references note. First point, the government of Rwanda's actions and denials indicate misapprehensions of its most fundamental duties under refugee law, but also, of course, under the assurances. Next, reforms from Rwanda have occurred across a range of scenarios, as you will see from the table. These occurred in recent airport pushbacks, in-country asylum claims, and also under a prior third country transfer agreement. And they have taken a number of different forms. Asylum seekers have been pushed back from Kigali Airport, both to the Israel-Rwanda scheme and recently to transit countries or to neighbouring countries in which they have no right to reside. They have been physically taken overland to Uganda or Tanzania, where they have no right to reside. They have been required to leave Rwanda within days and threatened with expulsion directly to their state of nationality if they do not comply. Now, UNHCR's number on reform, I would stress again, while concerning, must be viewed in light of UNHCR's warning at the top of the table that I hope you've managed to locate at note 1, that the overall numbers are likely to be a significant underrepresentation of the true incidence of reform. But the broader point we make is that there is, of course, no requirement in the context of a real risk assessment to locate a precise historic match for abuses, and nor is a compartmentalized approach to the assessment of future risk permissible. And if authority were needed for that proposition, we have cited MAH, Egypt, and given you the references. Next, timing. The Rwandan government persisted in reform when it had every reason to comply with its obligations under the Refugee Convention, because its ability to comply with those same obligations was under consideration by the Secretary of State at the same time and was about to be tested in this country through public scrutiny and almost inevitable litigation. 2 Afghans were fooled on the 24th of March 22 during the latter stages of negotiations for the MOU. A Syrian was fooled on the 19th of April immediately after the MOU was announced. We next have the issue of the government of Rwanda's resistance to UNHCR warnings and advice about reform, including where given at the highest level informally. So warnings, you heard a little about this yesterday, but can I just flag the details? Warnings were given by UNHCR and ignored by the government of Rwanda in the context of the Israel-Rwanda agreement. Then for the 2 Libyans expelled in February 21, UNHCR had warned in terms that their expulsion would constitute reform, but reform or expulsion nonetheless proceeded. For the Afghans in March...
Forgive me, which year were the Libyans?
February 21.
Thank you.
And for the Afghans in March 22, UNHCR directly contacted the Permanent Secretary of MINEMA seeking to prevent expulsion, which nonetheless proceeded. After the expulsion of these Afghans and of the further Syrian, UNHCR sent a note verbal stating that this had breached Rwandan laws and international obligations, as to which the government of Rwanda responded in unrepentant terms. You saw the response yesterday, the 11th of May note. And I should also say a further point about that response of 11th of May. UNHCR had said we can be at the airport, we can help. That's regard. All of this, of course, goes to the question of whether UNHCR can closely monitor the MEDP, which the Secretary of State seeks to assert. I shall turn now, in my remaining minutes, if I may, to Article 31 and take us quickly. On Article 31, first list of contacts, and I'm now at paragraph 9 of the references. It's axiomatic that the Refugee Convention requires a generous and purposive interpretation, but it must be interpreted in light of its humanitarian object, ST Eritrea. It must be regarded as a living instrument, as for. The aim of Article 31 is protective. It was recognised by the drafters of the Convention that subterfuge is a necessary part of flight for many genuine refugees. The need is all the greater in modern times, as Lord Justice Simon Brown, as he then was, noted in Adini, the combined effect of visa requirements and carriers' liability has made it well nigh impossible, his words, for refugees to travel without false documents. The protection, as Lord Justice Simon Brown said, extends to genuine refugees whose quest for asylum reasonably involves breaching the law, and extends, of course, to asylum seekers who must be presumed to be genuine refugees. That is important. That context is important, the reasons for Article 31, because there is always, as I shall come back to in a moment, the precondition of a causal nexus between the penalty and illegal entry of residence. Next, I turn to what is the relevant penalty here. The Divisional Court addressed, which UNHCR certainly did not advance below, the penalty to which UNHCR points is neither bare expulsion, nor is it subjective detriment, but those are the only forms of penalty that the Divisional Court addressed. The Canadian Supreme Court judgment, to which you referred yesterday, concerning deportation, is clear that obstructed or delayed access to the refugee process is a penalty. In UNHCR's view, state conduct prohibited by the Refugee Convention remains unlawful despite expulsion. I've given you a reference to a UNHCR note on that point in the Australian context. And indeed, I would note that the contrary position would be inconsistent with the broad humanitarian aims of the Refugee Convention and the purposive construction of Article 31 that is required. Conduct by a transferring state within its borders, which is prohibited Article 31, does not magically become lawful if it occurs overseas as the reasonably foreseeable result of the transferring state's decision. So, less safe, less fair refugee status determination procedures would be a penalty if imposed in the UK on account of illegal entry or presence. Suppose the UK said, those who entered illegally will be processed here, but they can't have a lawyer at the first stages of the procedure, or there will only be a single stage, there will only be a single hearing, for example. It is not less of a penalty because if, consequent upon UK decisions, that happens in Rwanda. So the Secretary of State says, well, we are suggesting that somehow it's a penalty because it happened to be in Rwanda. In fact, the converse is true. It's a penalty wherever it happens, and it's not less of a penalty because it happens to occur in Rwanda. The next point we make is that Article 31.1 can be breached even if Article 33 is not. And the point can be tested in this way. Take the example of refugee family reunion. Suppose a transferring state recognises a right for the immediate family members of a recognised refugee to join him, but the receiving state does not. Now suppose a refugee in flight leaves her child behind on account of illegal entry or presence, she is transferred to the receiving state. What's the penalty? It's not the transfer itself. It's the indefinite or permanent separation of the family. And parenthetically, although I don't propose to address that in any detail, mindful of time, Rwanda indeed does not offer a route of entry for the family members of recognised refugees, and we've given that reference. Turning now to paragraph 11 of the references note, what are the principal limiting elements? It's got to be a penalty, and by that we mean material objective detriment, and citing eminent authority, Professor Hathaway, often cited with approval in the highest courts of the UK, loss, disability or disadvantage inflicted for breach of a law or rule, and Professor Guy Goodwin-Gill, retributive or deterrent character. So it's got to be a penalty. But there must be the necessary causal nexus. It must be on account of illegal entry or presence. And reverting to a point that was the subject of questions yesterday, contrast the Dublin regime. Transfers under the Dublin regime occur independently of illegal entry or presence. Rather, transfers are based upon legally enforceable common minimum standards concerning the fair allocation of responsibility between member states. The aim of those criteria is to determine the closest connection. And we have cited elements of the preamble to Dublin 3, and I would note in particular objective fair criteria both for the member state and for the person concerned. And of course, transfers can, for example, occur in order to reunite a family. Next, coming directly, the drafters of the Refugee Convention. Drafters of the Refugee Convention inserted that requirement, as is clear from the commentary, because they were concerned to avert the secondary movement of refugees after finding asylum, after settling in one state. And there was universal acceptance, this is a point in Aspel, by the drafters that stays en route do not without more deprive a refugee of Article 31 protection. The key question, as it was put by Lord Hope and Aspel, is whether the refugee has stopped running away. And Section 37 of the 22 Act, on which the Secretary of State relies, can and must, in light of the principles articulated in Assange, be read compatibly with the refugee convention. Finally, this is a point pursued perhaps rather faintly now by the Secretary of State, penalties are not limited to criminal penalties. That is the consensus of the leading commentators, as the Secretary of State herself rightly accepts in her amended detailed grounds of defence. We've cited some of the authorities to that effect. And so for all those reasons, UNHCR does consider that transfer to the less favourable, less fair, less reliable, less safe asylum procedures in Rwanda do constitute a penalty contrary to Article 31. And that is so regardless of breach of Article. And my Lord, unless I can assist further, those are my submissions.
Thank you very much indeed. Mr. Drabble.
My Lords, can I first of all, a minor piece of housekeeping. I shall be referring, I think, to the ASM skeleton, the RM skeleton, and the two skeletons of the Secretary of State in AAA and AA. And if, I don't know whether the Board's got ready access to them, but I can provide the references if necessary. I have them loose and have had them loose for some time, and I anticipate the court may well have done so. That's why I'm only saying that now. Now, can I start by indicating order of the submissions and a thumbnail sketch of those submissions that I propose to make. There are three areas of submission. The first is the submission that Articles 25 and 27 of the Procedures Directive, 25/85/EU, remain EU retained law, and the Divisional Court misdirected itself in holding that they had ceased to be retained law by virtue of Section 1 and Schedule 1, Paragraph 6 of the Immigration and Social Security Coordination (EU Withdrawal Act) Act 2020, which I shall call ICSA. If this submission is correct, the Rwandan scheme is unlawful by reason of the fact that it does not require a connection between the refugee, fugitive refugee, and Rwanda, in breach of the Article 27, nor does it require a judgment that it is reasonable for that refugee to go to Rwanda. And both this scheme, the one that was present at the time of the decisions in ASM and RM, and all subsequent schemes are, as a consequence, unlawful. The second area of submission is the submission that the MEDP scheme, as set out at the relevant time, was inconsistent with the Refugee Convention and therefore ultra vires Section 2 of the 1993 Act. This is ground 1B of the ASM appeal. I shall take it together with ground 4 of the RM appeal, which is to the effect that...
I find it much more useful now we've got the universal grounds to use those rather than the...
No, sorry about that.
No, all right, if it's going to put you off your stroke, but that was the point of having a single set of grounds. Never mind.
Never mind. So I can only apologise. I've done it by reference to this letter. In any event, if I can just complete the sentence.
Of course, I'm sorry.
I don't think I'll make any difference thereafter to the...
Could you start the sentence again, Mr. Trammell, because I lost it halfway through.
The sentence is, this is ground B.
Yes.
Sorry, ground 1B of the ASM appeal.
Yep.
And I propose to take it together with ground 4 of the RM appeal to the effect that removal to Rwanda constitutes a penalty for the purposes of Article 31. Two grounds are closely connected. The ASM ground 1B proceeds on the basis that signatory states are under an obligation to process an asylum claim made by a putative refugee present on their territory, subject to limitations discernible from the scheme of the Geneva Convention. And the penalty argument, and I'm fully aware that it's been canvassed both by Mr. Binsky and to an extent by Mr. Hussain yesterday, so I shall keep it as contained as I can. The penalty argument proceeds on the basis that to subject the putative refugee to the detriment of a refusal to process the claim by treating it as inadmissible on the express basis that the particular putative refugee is an illegal migrant and for the purpose of deterring others from travelling to the UK is a penalty. The two aspects go hand in hand, and that can be clearly seen when we go to the academic material, which I shall do in a moment, and in particular the contribution of Professor Hathaway. And we say the two aspects are part of the basic architecture of the convention which the signatories signed up to. And the architecture is premised on an implied obligation to process claims. The existence of Article 31 demonstrates a recognition that putative refugees may travel in a manner which in other circumstances would indeed mean they were simply illegal migrants. Can I just stress that it's not necessarily for the purpose of those combined submissions on the ASM ground 1B and penalty to bottom out any debate about whether or not the threat of removal to Rwanda is actually a penalty for Article 31. The telling point is the basic concepts that are present in the Convention itself. I'll try to make that good when we come to Dublin 3, read together with the skeleton. And then thirdly, I hope to make submissions on the particular facts of RM designed to demonstrate in concrete terms on the facts of an individual case the submission on procedural fairness that had been made yesterday evening and this morning on behalf of Asylum Aid. We would wish the facts of RM to inform the discussion this morning as to whether 7 days could ever be sufficient as the standard period for representation after the service of a NOI. So the first issue are the Procedures and Qualifications Directive EU retained law. I can take your lordships first of all to the Procedures Directive, which is at Bundle 19, Unique Bundle 19, page 339, Core Authority Bundle. And if we can look at the central concepts.
Do you have the page in the core authority?
339.
Okay, thank you.
And that's the first page of the directive. And it starts out, as is common, with a long series of recitals. It is worth looking at recitals 1, 2, 3, 4, 5, and 6, so they're all relevant. One states that a common policy on asylum, including a common European asylum system, is a constituent part of the European Union's objective of establishing progressively an area of freedom, security and justice open to those who, forced by circumstances, legitimately seek protection in the community. And then there's a reference to the agreement to work toward establishing a common European asylum system. And in Title 3, the Tampere conclusions provide that a common European asylum system should include, in the short term, common standards for fair and efficient procedures in the member states, and in the longer term, community rules leading to a common asylum procedure in the European community. The minimum standards for laid down in the directive of procedures in member states for granting or withdrawing refugee status are therefore a first measure on asylum procedures. The main objective of this directive is to introduce a minimum framework in the community on procedures for granting and withdrawing refugee status. And then the approximation of rules on the procedures for granting and withdrawing refugee status should help to limit the secondary movement of applicants for asylum between some member states where such movement would be caused by differences in legal frameworks. Then when we come to the content of the obligations in the procedure directive, your Lordship will see at Article 25, page 351 of the bundle, reference to inadmissible applications. Circumstances in which a member state can declare an application inadmissible. first concept of the first country of asylum is in Article 26. Then Article 27 is actually the central article for my purposes. Member states may apply the safe third country concept only where the competent authorities are satisfied that a person seeking asylum will be treated in accordance with the following principles in the third country concerned. And then the Lordships can read the remainder of Article 1. And then subarticle 2 is 27.2. The application of the safe third country concept shall be subject to rules laid down in national legislation, including A. Rules requiring a connection between the person seeking asylum and the third country concerned on the basis of which it would be reasonable for that person to go to that country. So pausing there, this is a topic that we'll go back to fairly shortly in relation to the second area on which I'm making submissions. You have the introduction of the concept of a safe third country, but it's limited to circumstances in which, under pursuant to 27.2, there's a connection between the person seeking asylum and the fugitive third country, the suggested third country, on the basis of which it would be reasonable for that person to go to. And the advice for the present purposes of the MADP scheme is that it deliberately avoids doing that. It requires no connection with Rwanda, and it requires no judgment of whether or not it's reasonable for the refugee to go to Rwanda. Now, I understand that there's no dispute about that. The Secretary of State does not say the scheme is compatible with Article 27. It says that Article 27 is not part of domestic law. That's the point that's between them. If it is part of domestic law, then the scheme fails. And that is a very short but crucial issue between us. Obviously, we'll come back shortly when we consider my second area of submission to the concept of a safe third country. We say in the skeleton, the concept of a safe third country is not part of the framework of the Geneva Convention itself. It's the creation initially of the Procedures Directive in this directive. It's limited in crucial ways by the concept, by the requirement that it's reasonable for the refugee to go to the third country, and it's reasonable to go on the basis of a connection with that third country. Beyond that, you're creating a very extensive departure from the framework of the convention. So the crucial issue is whether or not the content of the Procedures Directive retained law after the coming into force of PISA.
I hadn't noted, I probably should have, that in fact 345B is with some very minor changes based or taken from the wording of 27.1. That's right, isn't it?
345B.
Oh well, don't spend time on it now. But I should have spotted that before. But I only just noticed that.
Yes, I mean the bit of 345 that's the contravenes 27 is the ability to remove someone to a safe third country if the original third country will not take them. Can I come back to it? Come back if we need to explore that any further.
So we want to turn to the.
I want to turn to
the Act.
Yes, I want to turn. Well, yes, I want to turn to the Act. Well, can I just make a clutch of submissions on the approach to the Act, in essence? we say we approach the Act on the basis of a submission which I will make good. There's absolutely nothing to suggest that the Home Office, as a sponsoring department of the Act, considered that the Procedures and Qualifications Directives had ceased to be retained law by the virtue of the operation of ICSA itself, i.e. Section 1, read together with paragraph 6 of Schedule 2. In particular, we will submit, this is obviously a crucially important submission, that the construction about the effect of ICSA does not flow from the language of Section 1, read together with paragraph 6 of Schedule 1, and I will make that good when we come to them. There's a pure textual submission. Secondly, the contention accepted by the Divisional Court about the effective ICSA is inconsistent with the long title of ICSA. It's inconsistent with the heading of Part 1, which contains both Section 1 and Schedule 1. It's inconsistent with the heading to Schedule 1 itself. Inconsistent with the very detailed explanatory notes to both the Bill and the Act. Inconsistent with the view taken by the Secretary of State as to whether the Procedures Directive was retained law, as stated to the Supreme Court in Robinson and in GVG, in NM against the Secretary of State in another tribunal case, and in Ainte, A-I-N-T-E, in another upper tribunal case. Inconsistent with the drafting of paragraph 17 of Schedule 3 of the Equality Act 2010, references in my skeleton, paragraph 17 of Schedule 3 of the Equality Act 2010, which recognises as separate the concepts of immigration and asylum. Inconsistent with the description of ICSA by the House of Lords Delegated Powers and Regulatory Reform Committee report on ICSA, and possibly more importantly, by the description of the same by the Home Office in a memorandum to the committee. So that's a memorandum put to the committee during the passage of the bill through Parliament. It's also inconsistent with the House of Lords Select Committee on the Constitution. All this is set out in paragraphs 16 to 25 of our skeleton. Next step is going to be to go to the Act, but before we do that, we submit that the sheer volume of this material provides powerful evidence that the Secretary of State never considered that ICSA touched the Procedures Directive until she took the view that it did in the course of this litigation. That's the first time that that view was expressed. Barristers have been sent off to court on quite a large number of occasions, accepting that the Procedures Directive remained retained law. That's the positive, in a way, no evidence that the Secretary of State ever thought it touched ICSA. The negative is that we have actually looked through all the parliamentary material, not suggest there's a petal and heart solution on the construction of Schedule 1 and paragraph 6 read together with Section 1, but there's absolutely nothing that we have found to suggest that Parliament was ever told, or anyone even suggested.
What the Secretary of State thought at various times is not an aid to construction of an Act of Parliament.
Well, it is if it's in the explanatory notes.
Yes, but not generally.
Oh, no. No, well, no, that's exactly why we're not putting in the piece of parliamentary material. We just maybe some comfort
Yes.
We do take some comfort from the novelty
Your-
of the
your-
submission
your-
made for the first time.
Your long list is a very comprehensive and powerful list
Yes.
of negatives.
Exactly. Yeah, well, exactly. I mean, that's all admissible. The long list is admissible. The parliamentary material that goes beyond that probably isn't.
But we do need to start with the language of the section
We do
itself.
need to start with the language of the section. So if we go to the Act, which is at bundle 29, tab 9, page 145, the bundle is called the Third Supplementary Authorities Bundle.
One four nine.
145, it's tab 9, 145. The long title states that we are dealing with an act to make provision to end rights to free movement of persons under retained EU laws and to repeal other retained EU law relating to immigration, to confer power to modify retained direct EU legislation relating to social security coordination and for connected purposes. I might need to come back to that phrase, and for connected purposes, but stopping short of it, nothing to suggest anything that touches asylum.
Well, I mean, okay. I mean, asylum is part of immigration, isn't it?
Well, not in any simple way. As we've explained in the skeleton, there have always been two concepts of one of, if you look at it in EU terms, one of freedom of movement and one of asylum. There's two separate schemes of freedom of movement and of asylum. The Act, I submit, is very carefully couched in terms of ending free movement. If we move down the page just for a moment, Part 1, and we're dealing with Part 1, we've got Section 1, which is the crucial section, and Schedule 1, which includes Paragraph 6, are both part of Part 1. So far we know from the long title, and we know from the heading to Part 1, that we're dealing with material that relates to free movement. No mention of asylum, and we could provide a list, if we needed to, a list of long titles and other references that specify acts which deal with both asylum and immigration as doing precisely that. And then we get Section 1, the heading immediately above Section 1 is repeal of the main retained EU law relating to free movement, etc. We need to come back to the meaning of etc. in the Divisional Court. Thought that was good enough to bring in asylum as an adjunct to free movement. We don't accept that. And then Section 1 then introduces Schedule 1, makes provision to, then A, end rights to free movement of persons under retained EU law, including by repealing the main provisions of retained EU law relating to free movement. That's not what we're concerned with, although it is related to free movement. B, end other EU rights and repeal other retained EU law relating to immigration. So at that point, in the relatively short trail of statutory provisions, we are dealing with a schedule which makes provision to end other EU retained rights relating to immigration. No hint, consistently with my long list, of any intention to touch the substantial asylum directives, which the Secretary of State says are in fact caught.
There's quite a lot of authority about the meaning of the words relating to in statutory construction.
Yes.
And
Well,
particularly in the arbitration context, which may not come to your mind.
the arbitration context doesn't, although I try to keep up.
But it is where you find the meaning of those words, and all I would say is those authorities show that the words are very wide.
Well, I can't.
My question, just to finish, Mr.
Yes.
Travel, and then I'll shut up, is that I would have thought there was at least an argument for saying that asylum does relate to immigration.
Well, I will show your lordship in a moment. We need to go to the explanatory notes and then to the government memorandum to the House of Lords Committee.
Okay.
Just to jump, the House of Lords Committee were told in terms that the only matters that were connected with the provisions of Section 1 related to free movement. Told in terms that words in connection with could not be used in a way which the committee was minded to treat as illegitimate, because it was obvious that the subject matter of Part 1 was concerned with free movement. And I said, it is indeed obvious. The Secretary of State was entirely right to say that. But I say, this is in a way, it's almost a jury point. It's what the Secretary of State told the House of Lords Committee when it was being pressed to remove the words in connection with from another provision, a power to modify by regulation, from that power to modify, and told you had a narrow reading. And we say,
But that can't be entirely right, can it, Mr. Drabble? Because Section 1, in describing the effect of Schedule 1, makes a distinction between free movement at A, even which is the only part of the title, and then other EU-derived rights relating to immigration at B. So on any view, it goes beyond being just about free movement, whatever the title to the part says.
well, it certainly, I don't need to say more, it certainly doesn't go beyond immigration.
Well, all right, but you were making a wider point, I thought.
Well,
saying it was
we'll
all
see
about free movement.
We'll see what the Lord was told. And my submission is the Secretary of State has a huge ask to say that by a side wind, he has actually revoked the main asylum directives without ever mentioning it.
Well, I'm sure you'll come to it, but are you able just with a couple of 2 or 3 bullet points to tell us what other EU retained law relating to immigration was repealed by this?
Yes.
So leave aside free movement.
Yes, because it's
So
set out in the explanatory notes.
All right.
So there's a list of it's stated to be a non-exhaustive list.
Yes, of course.
That is obviously held against me but there's a long list. It includes, the principal subject matter is what I think of as a Citizens Directive. It's 24 something or other. It's the 2004 Citizens Directive. But also issues like Zamvano carers who have a right of residence because of their status as a European citizen, Chen carers who have a similar EU right of residence. And it's matters of that sort. So in a way you could argue, I suspect, about whether the Zamvano situation is concerned with free movement, but it's certainly concerned with immigration, and is in the list, which we'll come to in 2 minutes, that were the subject matter of the explanatory note.
So in answer to my Lord's question, free movement, immigration, open brackets, at least some, close brackets, but not asylum. That's your solution.
That is exactly right. Yes, and we say that. I know the list in the notes, which we'll come to in a moment, is non-exhaustive, but it is a remarkable thing that if the intention was to repeal the Procedure and Qualifications Directive, it doesn't get a mention. And it
Before we leave statutory construction and section 1, which seems to me quite important in this exercise, at the moment, as I understand it, asylum legislation is mostly contained in things called acts, which have the word immigration in the title, and rules that have the words immigration in the title.
Yes, but very commonly, and I suspect almost always, the long title of the Act will be an Act relating to immigration and asylum if the asylum rights are, if asylum is the subject matter of the legislation.
If it helps you, Mr. Drabble, in the Court of Appeal, we refer to immigration and asylum cases always, not just immigration cases. So that's you could a forensic point you could have made.
Well, I'm very pleased that your lordships were doing that from the point of view of these submissions. I don't otherwise mind. But it does reflect a truth. There is a distinction, which is obvious on the face of all the material in my long list and more generally, between immigration and asylum. And asylum are the rights that, in essence, go back to the Geneva Convention on the Defence of Refugees. Immigration is freedom of movement and very directly analogous rights, such as Chen and Zambrano, rights flowing from EU citizenship, which entitle you to move around the Union, basically. And that's the answer to the question. The immigration is about moving around. I'll keep on going.
I'm afraid we've taken you out of your course a little. So we're still in section 1.
Well, that is section 1.
Yeah.
It contains a formula at the end of 1B. And other EU-derived rights and appeal other EU-retained law relating to immigration. My submission is that if that formula had been repeated precisely in those terms in paragraph 6, which is the next thing we're going to go to, it would have been impossible for the Secretary of State to argue that the Schedule 1 made provision to end retained rights relating to asylum. It plainly is not intended to on the wording of section 1. And if we go on to paragraph 6 of Schedule 1, 152, lordships will see the heading of Schedule 1 is repeal of the main retained EU law relating to free movement, etc. And then 6 over the page at 153. Other EU-derived rights, powers, liabilities, obligations, restrictions and remedies and procedures cease to be recognised and available in domestic law so far as they are inconsistent with or otherwise capable of affecting the application operation of any provision made by or under the Immigration Act, or B, they are otherwise capable of affecting the exercise of functions in connection with immigration. So my submission is that which we record at paragraph 21 of our skeleton. Probably no need to look it up, I'll just draw myself to it. Paragraph 26, I'm sorry, that was a false reference. It's paragraph 26 of our skeleton, which admits that the court, the Divisional Court, erred in its construction in the Act, and in particular the relationship between Section 1 and Schedule 1.6. Both are contained in Part 1 of the Act, and then refer to the long title and the heading. The Section 1 itself states that Schedule 1 makes provision to end rights relating to free movements and other rights relating to immigration. Section 1(6) then states which rights are in play for this purpose. Given the wording of Section 1 itself, there was no need for the draftsman to repeat the formula relating to immigration. This requirement is inherent in the whole structure of the Act. Court's interpretation expands the reach of Schedule 1 beyond that envisaged by the wording of Section 1. That is, in a way, the key linguistic submission, which in my submission is right and borne out by all the rest of the material, which I shall come to as shortly as I am. So if we then go to the explanatory notes to the bill.
So sorry, just one footnotey point. The Immigration Acts, I know it's in your skeleton somewhere, it's a defined term, but I can't see where it's defined.
It's defined, if you go back into the body of the statute, defined in section 61. If your lordship looks at
Thank you, I found it. Yes, thank
Act,
you. I just was looking in the wrong place. Yep, that's the answer. Thank you.
Section 4 provides the link back to section 61 of the Immigration Act.
Yep, thank you.
So I don't make a linguistic point. I don't make a point that something to do with asylum is not capable of affecting the operation of the Immigration Acts. I do make the point that both Section 1 and Paragraph 6 of Schedule 1 are limited by the key concept in Section 1. The EU chain rights relate to immigration. That's what the Act is dealing with. And what's more is what the Secretary of State thought the Act was dealing with. We'll see in the material in a moment. The explanatory notes of volume 26. Page 3219, the volume is Supplementary Authorities Bundle. Page 3219.
Page 3219
Yes,
in the supplemental authority.
yes, unless I'm told I got that wrong. Yes,
Which supplementary authority?
the one that's called the Supplementary Authorities Bundle because it was the first one.
Right. I've only got a second
Push it like
supplemental
that.
authority. I haven't got a supplemental authorities bundle. That's my JA can send me one.
It is unique, volume 26, but that doesn't help your lordship, as I understand.
Yeah, it is great. Anyway, you carry on and I'll find
Your lordship, if your lordships have got to the position, if you look at page 3220, there's a commentary on provisions of the bill.
Sorry,
3220.
Yes, thank you.
Commentary on provisions of the bill, Part 1, measures relating to ending free movement. And then Schedule 1, repeal of the main retained EU law relating to free movement, etc. So if I can then ask your lordships to look at page 3227. Paragraph 28 reads, this clause introduces Schedule 1, which repeals legislation relating to free movement and other EU law relating to immigration. So there, the draftsman of the explanatory notes is carrying over the connection with immigration, which is a central part of my case. which is retained in EU law by the Withdrawal Act 2018. The details are set out under Schedule 1, under the Schedule 1 part of these notes. And then just to foreshadow the content of the government memorandum, which is my next stopping point, paragraph 36 states as clause 4 of the bill did change in the sense of the numbering of the additional provision was inserted into the bill in the course of its passage. But as it stood at the time of the bill, clause 4 allows the Secretary of State to make such regulations as he considers appropriate as a consequence of or in connection with Part 1 of the bill. And then go on, 3230, paragraph 60. Part 1 of Schedule 1 repeals EU-derived domestic legislation relating to free movement. It revokes the EEA regulations which implement the Free Movement Directive 2004/38/EC, as I call the Citizens Directive, and it omits Section 7 of the Immigration Act.
So sorry, I'm just looking at something. Which
I'm
paragraph?
now paragraph 60 of the note, page 3230.
Paragraph 60, yes.
3230.
3230.
Thank you. I've got it.
You've got your push up. I'm sorry about that.
All right.
Your Lordships can read what paragraph 60 says. We're dealing there with Schedule 1. We've moved past Section 1. We're dealing with Schedule 1. And the note states that Part 1 of Schedule 1 repeals EU-derived domestic legislation relating to free movement. It revokes the EEA regulations which implement the EU Free Movement Directive 2004/38/EC and omits Section 7.
But we're concerned with Part 2, aren't we?
We're ultimately dealing with paragraph 6.
Yes, which is in Part 2 of the
No,
schedule.
no, it's not.
It's not? I think
No.
It's part 3.
Oh, of the schedule.
Yes.
Yes. It is of the schedule. It's all in Part 1 of the Act. And part, yes.
Part 2 of the schedule.
Yeah. And look, paragraph 68 states paragraph 6 ensures any directly effective rights that would have been saved by the Withdrawal Act would, in the absence of this paragraph, be retained, cease for time so far as they are inconsistent with or otherwise capable of affecting the interpretation, application, or operation of immigration legislation or function. For example, the resident rights which are derived from Articles 20 and 21 of the TFEU, rights of citizenship and free movement, will be retained law. Unless they are disapplied, will provide a right to reside in the UK for certain groups. For example, chain carers, who are primary carers of an EU citizen child who is in the UK and is self-sufficient. However, the rights derived from Articles 20 and 21 would continue to apply in non-immigration contexts unless disapplied.
So your point, no mention of asylum.
That's, I mean, in a sense, that's the whole of this exercise, yes. And all consistent with paragraph 6, shadowing section 1 in a way one would expect. And then if you go over the page, '69, the following is a non-exhaustive list latched onto by the Secretary of State and the Divisional Court. It is a non-exhaustive list of the directly effective rights relevant to this paragraph, and then your Lordship could run an eye down them. There is nothing that relates to asylum. They all fairly obviously relate to immigration. So it's an unavoidable feature of the Secretary of State's case. The omission of the Procedures Directive is an omission to which no significance should be attached, and that the verbal formula used in paragraph 6 is good enough to carry out, to achieve the purposes he or she wishes for this litigation, despite the fact that no one appears to have realised that was what was happening. That just has to be his case.
Doesn't it make it a bit complicated to disentangle the provisions of the Immigration Acts that relate to asylum and those that relate solely to immigration? Properly so,
Well,
on your case.
the simple answer to that is no, because Section 1 does it. I mean, if you just stopped at Section 1, that's what you would have. And that's what the drafts with the explanatory notes thinks you've got. The problem that I have to confront and do confront is the omission of the formula relating to immigration from paragraph 6 of Schedule 1. If it just repeated the formula in paragraph 6 of Schedule 1, I will be obviously correct. The case that the Procedures Directive ceased to be retained law will be unarguable. And we say that all the material shows that everybody acted on the basis that the formula was effectively repeated in Schedule 1. I mean, possibly also necessary to take a step back. This was obviously a heated moment in the Brexit process. We were ending free movement and associated rights like Chen and Zambrano. The idea that you were modifying the operation of the Geneva Convention as it works in the UK by removing the Procedures Directive without telling anyone is, in my submission, fundamentally unlikely. And all the rest of the material shows that isn't what happened.
But I'm sorry to press you on.
No, it's quite all right.
It's
a
a
central
point of interest, I think.
Yes.
Is that we're really not concerned with what people thought, as my lord mentioned really right at the beginning of this debate. I mean, the fact that the Secretary of State may not have understood her own legislation, or hundreds of parliamentarians thought that it meant one thing, if it means another, and it means another.
If it unambiguously means another, so that I can't avoid it, then that is true, but it doesn't, because there's sufficient material in Section 1 itself, which you don't read paragraph 6 of Schedule 1 by itself.
Well, I mean, we've got that submission. I'm just putting to you that the forensic case, which might be attractive if there were 12 of us, that, lots of people have said this or that, doesn't really get you anywhere. You have to be
my
right.
submission, in this context, it plainly does, because you are dealing with the relationship between two statutory provisions. It's a straightforward linguistic submission.
No, that's a linguistic. That gets you somewhere, if you're right. But
Yes.
What doesn't get you anywhere is saying that people have thought this or people have thought that, however important it may be.
I'm not even sure. I don't think I accept that. I mean, it may not be completely necessary for me because I win on the language. But I mean,
Get to pepper.
It's not inadmissible, though, is it? Because of the case law about the admissibility of the explanatory notes.
Exactly. No, none of this is inadmissible. My case is not inadmissible at all. It's the objective background against which you can construe the relationship between Section 1 and paragraph 6. Is paragraph 6 freestanding, not going beyond the ambit of Section 1, or is it limited by the ambit of Section 1?
I think perhaps where you went further than you need or frankly should was saying, oh, well, nobody could have thought that it meant this, as it were, divorced from the explanatory notes. But
well, I win if it's ambiguous because of the explanatory note, and the rest of the volume of material. It doesn't stop at the explanatory note, as we'll see in a moment. I'm just fine. Now, can I just take you to the next point of departure, is the Delegated Powers Committee and the Government Memorandum, which is in the same bundle, page 3212, so slightly earlier in the bundle, in fact. This is a memorandum to the committee.
Sorry, did you say 3?
The page reference for my quote is 3212.
Yes, I see.
So the government response sets out a recommendation which relates to what was then clause 4, which is a delegated power provision. You can see it dealt with on the explanatory notes. Wanted to go back to that. The recommendations remain of the view expressed in our earlier report that clause 4.1 contains an inappropriate delegation of power, and the law should be amended so that the words "or in connection with" are removed from clause 4.1. Government response is the changes which can be made using this power are restricted to those which are appropriate in consequence of or in connection with the provisions in Part 1. They can therefore only be used in relation to the ending of free movement and protecting the status of Irish citizens. And then it goes on to explain why it's still appropriate to keep in connection with.
Where is? I'm sorry, I need because as you've said, the
easiest way of understanding what that's all about. The easiest way of understanding what's all that about without going on a fresh paper shade is go back to the explanatory notes.
Yeah. Well, where did that end up in the bill, in the Act?
That's a very good question. The explanatory notes dealing with the delegation of power at
Section 4 of the Act is concerned with the meaning of
Section 4 of the Act is something else.
Completely different.
Delegated notes deal with clause 4 at page 3228.
Yes.
Let me see if I can find. Go back to the Act. Sorry.
Paragraph 36.
Yes, paragraph 36 of the notes introduces this precise
Yes, but it
point.
explains what clause 4 did.
Yes.
It would still be useful to know
It still
what
doesn't
it
actually tell
became.
you where in the present Act it
Yes.
is, which is why the question that in the Act. It's 5.1.
Section 5.1.
Section 5.1,
Right,
page
thank you.
147.
Yes.
So, the effect of the construction of the Divisional Court is on the face of it that you could use that power to make provision, such provision as the Secretary of State considers appropriate in consequence of any provision in this part, which would include Section 1 and Paragraph 6 of Schedule 1, as construed by the Divisional Court. That's flat contrary to the understanding to what the committee was being told in terms about the lack of a need to remove in consequence of. And obviously, that approach to the meaning of in consequence of has implications for the word etc. in one of the long titles and relating to, in answer to the Lord Master and Paul's questions about what one might find in arbitration. However wide that concept is, in consequence of or relating to or etc., it's not wide enough to go beyond what the Secretary of State thought was the scope of Part 1. I repeat the submission, it all looks as if the Secretary of State is right, it's all been done by accident. No one knew they were doing it, and the wording doesn't require you to construe it as having happened. we go on then. That's the most immediate parliamentary material. The two Supreme Court cases in which the Secretary of State has continued to take the line. This was taken by the drafter of the explanatory notes that Part 1 of the statute is concerned with free movement and immigration and not anything else. And the two, you need, see that it's its strongest if you look at a case called Robinson first, which is tab 21, sorry, unique bundle 21. And this is about the ability to remove Zambano carers on public interest grounds.
You haven't got a page, have you?
Sorry, my lord. We are dealing. At page 2112 is the core authorities bundle. It's the core authorities bundle, page 2112.
Yeah.
It's to do with removing. Sorry, it's to do with whether the UK can remove someone who is claiming the right to reside on being a Zambano carer. The answer is yes, you can. That doesn't matter for these purposes. The judgment, not completely irrelevantly, is given by Lord Stevens. And he explains what the Secretary of State's view was of the EU position at paragraph 29 in the judgment. Page 2132 of the bundle. Sets out the position of the IP completion day, and your lordships will see the second half of the paragraph. This is subject to the Immigration and Social Security UNHCR, as well as secondary legislation made under it. This Act provides for the repeal of the main retained EU law relating to free movement. So there's Lord Stevens, aware of ICSA, describing it as repealing main retained EU law relating to free movement, that which is directly relevant to Zambano carers, as we've seen from the explanatory notes. My submission one reads paragraph 29 of Robinson, together with the later case when ICSA was in force of GVG. And in this, if you go to (2181), that's wrong. 2270.
Well, 2181's the start.
Yes.
And you want 27.
I want to be in the Supreme. The danger with BMVG in particular getting too far engaged in the Court of Appeal. We want what happened in the Supreme Court.
Yes.
And there's a passage which starts at 2268. Under the heading, the legal landscape governing asylum applications. And there's a description of material which will be familiar to this court from the argument in this case. Skipping that, going straight on to paragraph 84. Lord Stevens, who knows about ICSA, we know that from Robinson, we've just seen it, says the Secretary of State accepts, in paragraph 84, accepts for the purpose of this appeal, and I agree, that the relevant provisions of the directive which are the procedures and qualifications directives, that's what G&G was about, are directly effective and remain extant and domestic law is retained EU law after the United Kingdom's withdrawal from the EU. We had an argument below, which I'm going to mention, that was actually binding authority, Lord Stephen giving informed agreement to the submission of the Secretary of State. I don't want to push that. But what we have plainly got is a series of expressions of view to Parliament in the material we've already seen, and to the court in Robinson, and in GVG, and in the upper tribunal cases we referred to in the skeleton. The Council have gone off to court, having been instructed by the Home Office that ICSA hadn't achieved the effect preventing the procedures and qualifications directly being retained law.
Well, again, what's the effect of that apart from being forensic?
By itself, it really doesn't resolve the case. You go back to if there were no force in my submissions about section 1 and paragraph 1, then so be it. But clearly is force in it, and it's everything else is consistent with that case. That is the material.
Mm-hmm.
And we say, no point in repeating the submission, that is the submission.
Thank
Yes.
you.
I mean, is there a particular criticism you've got of the Divisional Court's decision on the construction point to the contrary?
Yes, we put it in the skeleton. It shelves the explanatory notes on the basis it got little help from them. It says that the provision is unambiguous without considering at all the relationship between Section 1 and Schedule 1. It's explained Robinson and GVG on the basis that effectively there had been no argument and Lord Stevens had simply got it wrong. And all of that, we say, possible, but highly unlikely, given the starting point is the admissible material in the explanatory notes, which are clearly, strongly in our favour. The Divisional Court says they're of marginal importance. Frankly, if you list a set of directives which don't include the directives which on the Secretary of State's case are two of the most important directives which are being revoked, then the inference is that you, the Secretary of State, didn't intend ICSA to have the effect that is being contended for by the Secretary of State.
Thank you.
Yes, so now we go to Article 31.
Now we go, well, not
straight, we go via Section 2.
Well, yes, and slightly more than that, because I haven't got much time to do two exercises. But we are keen to make it clear that our case doesn't depend on Article 31 by itself, or indeed will be exactly the same if Article 31 were, say, limited to criminal penalties, and therefore not in play at all here. We would still have the same case. And can I just make good that by inviting your lordships to look at where we put it in the skeleton.
Is this the ASM one?
The ASM skeleton.
Yep.
Yes. Paragraph 41 of the ASM skeleton sets out section 2, and then fourth submission. Fellow contends that the MEDP scheme, as set out in paragraphs 3, 4, 5, A to D of the rules and associated guidance, ultra-virus section 2, because in summary, the rules must be interpreted and applied consistently with a good faith interpretation of the UK's international treaty obligations, absent clear and unambiguous language disavowing such obligations, Salomon. The rules permit the removal of a presumptive refugee on UK territory to a third country with which he has no connection, without substantive consideration of his asylum claim for the express purpose of deterring other claims by refugees on the basis of mode of travel to the UK. Such a scheme is contrary to the spirit and purpose of the Refugee Convention. While a constrained application of the safe third country concept may be consistent with the Convention, as reflected in the restrictive scope of the Procedures Directive and Dublin 3, the scheme in paragraphs 3, 4, 5, A to D is not so constrained and is consistent with a good faith interpretation, inconsistent with the good faith interpretation of the Convention, as reflected in both the wording of the Convention, its intention, and subsequent implementation by consenting parties. And the whole of the remainder of the skeleton through to paragraph 64 in particular is obviously relevant to this submission. It isn't fundamentally dependent on the concept of penalty. It's a submission that if you are on the territory of the UK, you are a presumptive refugee. As Mr. Dubinsky submitted, the UK can't act inconsistently with the framework of the Convention in those circumstances. And to remove someone to a country with which you have no connection, and in circumstances where it is not reasonable for you to go there, is itself inconsistent with the intentions behind the Convention. We set all that out, in particular paragraphs 53 to 56. And we have some submissions about the permissible scope of the safe third country concept at paragraphs 57 through to 64. I'll come back to that after my next stopping point, which is Dublin 3, because it's my submission that Dublin 3, which was relied upon by Lord Panic below and by the Divisional Court as an example of how the Article 31 contemplates a removal from the UK to a safe third country. My submission that mistakes the whole thrust of Dublin 3 itself. The launchers will go to Dublin 3, which is supplementary authorities bundle 1, volume 23. Oh, it's volume 26. No, it isn't. 23.
What a page.
It's page 17. What Dublin? I've got the wrong directive. I am right. Which page? I'm suddenly worried I was dealing with some earlier version of Dublin. Got this completely wrong, but I don't think I have.
This is the 2013 version.
Yeah.
I think.
What page are we on?
And page 17 of the bundle.
17.
Tab 2.
Thank you very much. Now, taking this quite quickly, if your lordships read the recitals, I'm not inviting you to do it now for time reasons, you will find that the objective behind Dublin 3 is expressed, for example, in recital 4, of providing a clear, workable method for determining the member states responsible for the examination of an asylum application, and in recital 5, based on objective, fair criteria, both for the member states and for the persons concerned, should in particular make it possible to determine rapidly the member state responsible so as to guarantee effective access to the procedures for granting international protection and not to compromise the importance of the rapid processing of applications for international protection. So the whole of the purpose, as expressed in the voluminous number of recitals, is to produce a clear, efficient, and fair and effective system of providing protection. The whole thing is done to facilitate the working of the Refugee Convention, not to frustrate it, but to facilitate it. We can go on to understand what is actually involved. If your lordships look at chapter 3, page 25 of the bundle, Article 7 deals with the hierarchy of criteria. It tells you that the criteria for determining the member state responsible should be applied in the order in which they are set out in this chapter. And the order of the criteria are Articles 8 dealing with minors, Article 9 dealing with family members who are beneficiaries of international protection, where an individual has been allowed to reside in a state as a beneficiary of international protection, the member state should be responsible for examining the application for international protection. Then the important words, provided that the persons concerned express their desire in writing. Similar caveat to Article 10. And then Article 13 provides a modest application of the concept which we accept is inherent in Article 31 of the Geneva Convention, as the consequences of not having come directly. Lordships, cast an eye down Article 13. Where an applicant has irregularly crossed the border into a member state by sea or air, having come from a third country, the state thus entered shall be responsible for examining the application for international protection. That responsibility shall cease 12 months after the date on which the irregular crossing took place. And then that's shifted if you, the fugitive refugee, have been living in the member state for a period of 5 months. See 13.2 and the fallout words at the foot of the page if you've lived in several member states for more than 5 months. So if you look at this as an issue of whether this is compatible with the learning on Article 31, Article 13 is plainly carrying into practice the observations in the academic commentary, going to be one of my last stopping places. That the wording of Article 31 itself envisages removal to a first asylum country. But we submit is otherwise a very modest extension of the concepts implicit in the Geneva Convention themselves. And the reliance by the Secretary of State on Dublin 3 as somehow legitimizing a hostile system of removal is simply, in our submission, misplaced. We take it in full. So that is Dublin 3. And finally, on this subject, go to the academic material. I was going to go to B10, the Canadian case, but I won't. I've seen it now twice, and I do rely on it. If you do get the chance to look at the list of academic commentators read by the Canadian Supreme Court, they include, unsurprisingly, Hathaway in an earlier edition. Of course, the present edition approves of B10. And if you look at Hathaway himself on Article 31, you will find Hathaway at bundle 22. Two passages on Hathaway that are relevant. The first is that at page 3723. Can I reverse that? Can I go to 3717 first? And there's a passage that starts in the middle of page 3717. Records the debate, the process of drafting of the revision.
Which edition are we in? We've got in the middle of this tab, we've got a title page which suggests the second edition, but it follows this bit. Is this an earlier edition?
No, I think this is the second edition.
Right, okay.
And it's obviously not the edition referred to in B10.
Yes.
Because if you read the text in full, it cites with approval the conclusion in B10.
Okay.
So, first edition cited to Canadian Court in B10.
Yep. This
is the second edition. I'm taking it very shortly indeed. If you look at 3719, Hathaway writes, for example, the assignment of refugees who arrive irregularly to abbreviated procedures is in essence a penalty inflicted for illegal entry, for unlawful entry. The summary procedure is resorted to not on the grounds of substantive insufficiency of the claim, but rather to sanction a refugee or his or her mode of entry. Such procedures take on a decidedly punitive character, because the essential purpose of Article 31 is to insulate refugees from penalties. For the act of crossing a border without authorization, the refugee may not lawfully be denied access to ordinary legal entitlement to a complete refugee status inquiry simply because he or she has used false documents to enter the country, otherwise entered in breach of contravention of migration control laws. And then footnote 1109 is a reference to B10. So on the meaning of penalty, any detriment imposed for the purpose of sanctioning the mode of entry is a penalty, according to Professor Hathaway. The passage that was relied on by the Divisional Court, by the Secretary of State in front of the Divisional Court, and the Divisional Court itself, is the passage at 3723, where he records the debate about the drafting of Article 31. This contains a statement the middle of the page, the potential devastating impact of the clear decision not to exclude expulsion under Article 31 is mitigated by two key factors that he sets out. So he does accept there was a decision, well, his view is there was a decision not to preclude expulsion. But the reason for that is immediately above. In the last part of the immediately preceding paragraph, as such, the Irish Court of Appeals worry that Article 31 might interfere with the operation of an orderly system to allocate asylum responsibilities, is in fact answered by the article itself. First country of arrival rule cannot be successfully attacked under Article 31, as the sanction imposed under such systems is precisely expulsion to another non-persecutory state. So in other words, as I understand the reasoning, the requirement of having that you come down to be immune from penalty, that you come directly to the state in which you claim asylum, is the basis for the ability to expel. But that is pure expulsion. The passage doesn't say anything about the situation we have in the present case, where the expulsion to Rwanda, albeit to a safe third country, is one which is not reasonable for you to go to of your own volition. We know that because of the absence of any such concept. As Dubinsky says, it's to an inferior asylum. Most importantly, it's simply to a different cultural and family situation. That's axiomatic in the situation. That is a penalty. And all the authorities, including in particular the most relevant B10, are consistent with that position. So true it is, expulsion is not ruled out because the first country of arrival rule remains in place. But we know from Dublin 3 that safe third country goes we know that what is happening in the Rwandan case is something other than a pure safe third country situation. Those are my submissions.
Can I just be clear about it? So I thought at one point it was your submission that pure expulsion is not contrary to the convention, but expulsion with a purpose of punishing illegal entry is.
Yes.
So that is the essence of the submission. It's the penal intention, or if you like, the deterrent intention.
Yes.
That renders it contrary to the convention.
I only need to say more that the deterrent intention is present on the face of the scheme. That does render it contrary to the convention. The thing we know is not contrary to the convention on the basis of the reasoning of Professor Hathaway is following through the logical consequence of Article 31 itself, so that if you have not come directly to the country in which you claim asylum, then Professor Hathaway certainly accepts that you can be expelled to the first country of arrival. There's certainly nothing in the passage which accepted the expulsion at large is acceptable. It's enough for me to say that if it's done for the purpose of deterring others exercising their rights, then it's a penalty.
Does it matter if it's done for deterring a potentially small group from exercising their rights, as you would put it, but the express purpose of the policy is to interfere with organised criminal activity, trafficking people across the channel, and to deter people from exposing themselves to risk of death, which unhappily is materialising from time to time. In other words, I understand your argument if it was simply anyone who arrives in the UK illegally, so on false documents, on the Eurostar or whatever the case may be. If everybody were covered, I see the, if I may say so, the elegance and simplicity of the argument. But does the express purpose of the policy have any bearing on this at all?
Well, I think my ultimate submission is no. I mean, you are applying the policy to the individuals with a detrimental effect on the person who is present in the UK and making his or her claim for the purpose of affecting not the person who is in the UK, but other people from operating the machinery of the convention. And that is the penalty. We also say, I mean, that's on the first limb of the ASM version of the argument, it is contrary to the spirit of the convention. It would be different if there was a safe third country which would take them back. Then first of all, I mean, i.e. the first country of arrival, and you could go sent back to there, then you will be in straightforward Article 31 territory. And the operation of Article 13 of W3 would operate in a rather more benign way than this policy, but they would still operate, following the logic of Article 31. But that isn't what's happening here. The safe third country position is being extended to include countries who have no connection at all. And at the end of the day, you say that's not a legitimate way of dealing with the individuals who've got here. Now, I was going to make submissions about RM. I'm not going to spend any time at all, but can I just...
Because otherwise you're eating into Miss Knight's
I completely understand that. I'm sensitive about that. But can I just take some... I just... Can we invite your lordship, when you have the time, to read? We have a very detailed chronology in the skeleton of RM, which runs about 3 pages after in paragraph 6. What it is. Paragraph 6. It goes on for 3 or 4 pages. Yeah. You then have precise submissions, which I won't read, paragraphs 24 to 26 of the skeleton, explaining what was unfair. And we summarise at paragraph 31 of the skeleton. The time frame which actually occurred in RM's case. Now, your lordships haven't actually had the facts of a individual case illustrating how the timescale worked, because for obvious reasons in the asylum aid case it was a generic challenge, and AAA haven't repeated their own facts either. It was looking at the reality of the debate this morning about whether 7 days could ever be enough. We ask your lordships to judge it by the chronology in RM and the summary of the time frame, in particular in paragraph 31, but more generally in the RM skeleton. The answer we give to the question, and I'll sit down when I say this, is that 7 days will almost never be enough. You've got to just imagine, I think as was submitted this morning, the exchanges that are necessary between the arrival in the UK, the grant of legal aid and all the steps that are necessary. It's not going to happen in 7 I don't think anyone suggested that there was anything tardy about the processing of the claim in RM's individual case, or just within the time frame it took. Those are my submissions.
Thank you, Mr. Drabble. Ms. Knight.
Right. I understand I've got till 4:30, is that correct?
That's right.
So, although we have 2 grounds of appeal, we're not going to add to the very detailed submissions made by Mr. Bain yesterday, and indeed Mr. Divinsky this morning, in relation to the duty of inquiry and the evidence. So I think we should therefore move to the grounds of appeal, which is now the sole focus of AS in relation to the lawfulness of the policy, Gillick, and whether a different test applies in the context of Article 3, real risk and Munjaz. We're conscious of, by Lord, the Vice President's observations when granting permission that if those initial grounds succeed, then the safety of Rwanda, then it may be that the guidance will fall in any event. But we do say that we have a distinct approach, which in relation to the lawfulness of the guidance and what it directs the caseworkers to do, in relation to the structure of the decision making, whether it creates a protection gap between matters that cross over from Article 3 human rights claims in the non-protection sense, or traditionally non-protection sense, and to the Article, the 345B question. We've set that out in our skeleton argument at 86 to 90 and 91 to 94. That's the unlawful compartmentalisation question. So, in the core, just for the avoidance of doubt, this issue formed, as my lords are no doubt aware, one of the list of generic issues that was before the Divisional Court. It was at issue 2, when the list of issues divided up between the various parties, and who proceeded, just again for the court's reference, that's volume 31, but tab 2, page 8. Is the Rwanda removal policy, Gillick unlawful because it would inevitably result in some decisions which breach Article 3 rights? That was how the question was posed before the Divisional Court. And I note, and it was the ground was pursued by AAA because that was again the division of labour between the parties, but AS and indeed all the appellants expressly relied on, I think, the generic grounds that were taken, as well as their own individual cases. And my lord noted as well in the Divisional Court's judgment, I think yesterday, that paragraph 72 there was fairly cursory or summary consideration of the question of the policy at paragraph 72 of the judgment, and nothing further is addressed directly on the question of the policy. So I will take the court. We make our 5 core submissions that we say out of paragraph 63 of our skeleton argument, and I will take the court to the policy, albeit that it is a sort of brief traversing of the policy in the current time frame. Importantly, just again, as the AAA submissions have said, there is no statutory certification that Rwanda is safe. There's no immigration rule that says Rwanda is safe. It all originates in policy terms, i.e. the terms of the inadmissibility guidance and the CPIN source. And it's of note, and again, I'll take the court to it, but at page 4 of 30 of the inadmissibility guidance, which the court will find at Common Bundle Volume 3. You don't need to go there just at this moment. It's tab, Volume 3 of the Common Bundle, tab 21, at page 964, it starts. It's quite clear that the inadmissibility, unsurprisingly perhaps in the context of this challenge, it's quite clear that this guidance was amended specifically with reference to the MEDP, the announcement of the MEDP, and the guidance was amended on the 9th of May. So that's why the guidance was amended, that's the context for its amendment, and within that guidance,
can I just be clear about that? I hadn't appreciated that there was a version of the guidance before the MEDP.
Yes. So the guidance, the inadmissibility guidance traditionally those terms cover. It's called inadmissibility safe third country cases. Historically, that dealt with doubling cases predominantly, or
Yes, I
almost
see. Thank you.
exclusively. And then it was amended.
Well, page 4 says that. It says updated to reflect the MEDP.
Yes, that's at 967 at the bottom. Yeah. Changes from the last version of the guidance. So there's no doubt about what it was, why it exists, and what it was doing. So our 5 core submissions are that in assessing the lawfulness of policy guidance to decision makers, there is a risk of Article 3 breach. We say the court should look at it in the Munjaz context, i.e. whether there is a real risk. That's, we say, uncontroversial for the type of case that this is. In relation, as a matter of principle, whether the court finds as a matter of fact is another matter. But as a matter of principle, and that, as I understand my Lord Chief Justice's judgment of the Supreme Court judgment in A, that's my clear reading of paragraph 79 of that judgment.
79 of what? A.
Of A in the Supreme Court of my Lord Chief Justice's judgment. And so that the question, that the test there is whether there's a real risk. We say the inadmissibility got a breach of Article 3 breach by applying the guidance. I know the Secretary of State's case here and the Divisional Court case is that it's not a blanket and that individual circumstances have to be considered. But the way we say the guidance in fact operates is that there is effectively, as my learned friend Mr. Stain set out yesterday, there is a direction to caseworkers that there is a presumption that Rwanda is safe, and that the Secretary of State doesn't have to do anything more in those circumstances. She says it's safe, and unless you advance a case about why Rwanda isn't safe for you, which is going to be difficult to advance for the reasons set out by Ms. Kilroy in terms of timing, but also in terms of substance, and also in relation to the evidence that we've heard both from AAA and from UNHCR. An individual is unlikely, if not, and the AS is a classic example of somebody who didn't have information about why Rwanda might be unsafe for him. He advanced a medical case about his own vulnerability, but he didn't know how to further articulate that in relation to how it might impact on the risk of access into the Rwandan asylum procedure. And separately, for reasons we set out in paragraph 51 of our skeleton, he didn't know about the UNHCR's criticism of the Rwandan asylum procedure, so that that bore on his claim, because his claim is as a Christian convert, and it impacts on the HJ Iran principle, which is effectively the right to not have to be able to manifest one's religion, which is not something that Mr. Botanic explains in his written statement. For UNHCR LB2, you don't have to go there. The references are in the skeleton of paragraph 51. But those sorts of principles couldn't have been known to the individual AF, or indeed as various parties would any individual. And so we say that the court has to assess the guidance for itself as to whether, in light of that, the history that we have just been looking at for the last almost 2 days now, whether there is a real risk of treatment contrary to Article 3. And that's our primary argument. And the alternative argument is in relation to whether there is, the guidance is if the court were to find that there was no real risk in general terms, whether the guidance is in any event unlawful because of the structure of the decision making. And we just remind the court that in this case, or in many of the decisions, were quashed, the individual decisions were quashed by the Divisional Court because of a failure by the Secretary of State to join up the different parts of decision making and to unlawfully, in some cases, compartmentalise the way that the human rights claims were made and the content of them. So the Secretary of State relies on the fact that, unsurprisingly perhaps, that the guidance requires individual assessment to follow after a person is relying on a safe third country. After the Secretary of State is relying on Rwanda as a safe third country. But we say that this fallacy exposes the problem, which is that, as we've said, the individuals will not be able to make any meaningful representations, and the burden effectively is on them to make out a claim. So there is nothing in the guidance that identifies the type of case where indivisibility might, where a claim might be held to be admissible under the principles of 345B. It doesn't set out. I will take the court guidance in a moment, but with a few moments we have. But just to say that Rwanda is treated as safe, and it doesn't even identify how a person might displace the presumption that Rwanda is safe. And that's, we say, identifies where the risk lies. So even if the court is, with the Secretary of State's analysis, that Gillett doesn't positively authorise, direct or mandate unlawful treatment by the application of the policy, there's still, we say, a risk based on how it applies in individual cases, because of the reasons that we've set out, which is that there's no way, in meaningful way, that an individual could actually advance a claim that would displace that presumptive guidance and the shifting, the sort of the evidential burden that we say that the policy has created. So if I can just take the court.
But do you accept that if the policy is applied as the Secretary of State has set it out, that then there's no breach of Article 3? But secondly, your submission, and the submission of everyone we've heard, is that for various reasons in Rwanda it won't be applied as the Secretary of State is expecting?
Well, we certainly say for the reasons, the evidential reasons, it won't be applied as the Secretary of State is asserting. But in terms of what the Secretary of State says is, and the Divisional Court's approach.
That's Munjaz, isn't it?
Yeah, that's Munjaz. The Divisional Court's approach was to say 345B requires, in the rules, consideration of whether the country is a safe third country for the particular claimant. And it's the emphasis on for the particular claimant that the Secretary of State relies on, indeed the Divisional Court relies. But there's nowhere that you can see in my submission, on our submission in the guidance, as to how, in fact, the for the particular claimant aspect would be identified. Because the claimant doesn't know, and the Secretary of State doesn't address the question herself, with reference to the evidence that is now available, and even arguably with reference to the material that she had at the time. But we're not concerned with those temporal limitations for the purpose of this challenge. So the Secretary of State relies on her. If I can just take the court to the policy, which is the back where I indicated it, volume 3, tab 21, page 964. Question of whether the policy is supposed to be interpreting the rules, which are 3, 4, 5, A to D. And in fact, as a point of observation, we are at odds with, or the Secretary of State is slightly at odds with what the guidance is doing, because the guidance only addresses 3, 4, 5, A to C. So in answer or in observing a response to my Lord the Vice President's point about where does the D discretion fit in, the guidance is entirely silent on how to exercise the discretion. If I could, those rules are actually conveniently set out in the policy document at page 994. And at 995, so if I can just look, I don't think anyone's particularly taken the court to the structure of the decision making, although Miss Kilroy's annex to her asylum aid skeleton does set out the steps there. But if I can just highlight to the court that the 994 inadmissibility of non-EU applications for asylum is at 345A, and that's the trigger clause about how persons have travelled or what countries they've travelled through. We don't dispute that. What's then defined as a safe third country of asylum under the rules is for a particular applicant 345B to C. And the reason it says for a particular applicant is because this isn't a statutory presumption case.
345B, surely.
345B, I apologise, I said so. You then have the first criteria, which is are you at risk for a refugee convention reasons effectively in that country? Will that country, then the little Roman 2, will the country respect the principle of non-refoulement? And the third question in relation to Article 3 is is there a prohibition on removal in violation of Article 3? That's little Roman 3. And the 4, the possibility exists to request refugee status, which is in terms of access to procedure and to receive protection. And then 345C says if the application is treated as inadmissible, Secretary of State will attempt to remove. And then the exceptions to for the admission of inadmissible claims. The Secretary of State says that where an application has been treated as inadmissible, and then either we're not concerned with one about reasonable period of time, or upon consideration of particular circumstances, the Secretary of State determines removal is inappropriate. That part of D2, which is part of the rule, operates as an exception, or should operate as an exception, to the question of whose claims are going to be treated as admissible or inadmissible, doesn't feature anywhere in the guidance. So that's why we say, alternatively to the question of risk under the guidance, there are no criteria. This is also pleaded in AS's original grounds at paragraph 118. But in any event, the guidance is absolutely clear. It's clear in its absence, if I can put it in those terms, that when the guidance is looking at 345D, it only refers to so 345D, you can see that at 28, page 28 to 30 at 991. There are no criteria. Oh, sorry, perhaps that's not the best reference. There are no criteria set out in the policy as to how that. Oh yes, the better reference is actually at 18 of 30, page 981. That does deal with 345D1, which is the delay point, but then doesn't have any reference to how to deal with inappropriate. And the reason that we say
yes, there's a bit of a puzzle anyway. There's also a reference at 976 in the last paragraph.
Yes.
Under the heading of suitability. Says decision makers must take into account country information of the potential country to where removal may occur in deciding whether referral into a particular route is appropriate in the particular circumstances of that claimant. That appears to be a reference to 345D, but I agree it doesn't appear to give any guidance, apart from saying you must look at the country.
And there are no criteria, but what it does mandate the decision maker to do is to look at the country information, and the only country information, absent the claimant being able to mount the detailed and specific analysis of the criticisms made about the country information in the CPIN, the only country information will be the CPIN that says Rwanda is safe in general terms. So although on its face it says for a particular individual, the policy says at page 20 to 21, if you make specific allegations and it's supported with country information, more detailed consideration may be required. Again, in practice, pursuant to the argument.
It's slightly odd because the whole point about 345D2 is the country has been held to be a safe third country under 345C for that particular individual. Yes. So this is a separate, 345D2 is a separate exercise from the safety exercise. That's how I read it.
And my Lord, the reason we say that exists, or one reason it may exist, is because there is a protection gap between what falls into the human rights claim. So you see in the guidance it says non-protection based human rights claims, that's 24 of 30, medical claims, family members and so on. They go into the human rights basket, and then you've got your Refugee Convention Article 3 removal case in the context of Rwanda, that's 345, which we just 5B.
But would not a human rights point fit appropriately under 345D2, say it was an Article 8 claim?
Well, yes, it might do, and that would be a relevant consideration before a claim could be that was deemed inadmissible on safety grounds to then be treated as appropriately also to be transferred. It goes to the removal question, but importantly, we say as AS did, AS advanced a case about his medical claims that I'm vulnerable. It will lead to deterioration of my health if I'm removed to Rwanda. But he also raised the question of whether he could access the asylum system in Rwanda in light of his vulnerability and that health. He didn't know any more about it, but he just advanced the sort of factual case. And that is not covered by 345B, 1, 2, 3, and 4, possibly 4 in terms of access to the asylum system. But where there's a gap in the decision maker's mind as to where that piece of evidence fits. The human rights decision maker, remembering these cases were decided by 2 different departments, one in Glasgow, one in Croydon. The one group, I can't remember which one was which now, said, I'm looking at Rwanda, it's safe. You've raised the medical claim that the Rwandans aren't going to remove you in breach of that from Rwanda to a third country, whether it's Iran or elsewhere. And the human rights decision makers said, well, the deterioration wouldn't be so serious as to engage Article 3 if I remove from the UK to Rwanda. But what nobody considered was how the impact of his medical condition in the Rwandan asylum system, i.e. the Article 3 situation for him in Rwanda, that we say that doesn't fall within the logic of the way the guidance is structured. And so, absent there being a particular way in which 345D could operate on the policy, it doesn't, I mean, it could operate on the policy, but the policy doesn't make any reference to it. So we say the policy falls because of that structural failure, which actually is what we've seen in many, if not all of these decisions that are under challenge, that were under challenge, almost all of which were quashed by the Divisional Court. And so that's where we say that there's a gap in the guidance. So that's the point we say we can make out on an ordinary. It's either an ordinary Gillick test because the rules and the policy don't match, because there isn't anything in the policy that addresses rules 345D2. So that's a straightforward omission on the part of the Secretary of State, we say. But our primary argument, as the court is aware, and we have it set out in some detail in our skeleton argument, is the question of whether in fact the guidance is unlawful because applying the Munjad's test and the way, even if it, and the question then is, even if it doesn't lead to an unlawful outcome in every case, that and we don't, or if it's, you know, even if we're not looking at the legally significant number of cases in the normal and human rights analysis, there is a real risk, as there was for, or as there might have been for Mr. Munjaz if he had made good case on the policies in his situation. And that's why we say that the policy is unlawful. And therefore, there are proper grounds for this court to adopt a more intensive review. And that, we say, is also supported by the reference at paragraph 86 in the RH Ashford Hospital case. I think just for the court's reference, because that's an authority that came in late, I think, or rather not in the main bundle, volume 16, I have that case. No, sorry. I'll just get the reference.
Which authority is this?
The RH Ashworth Hospital, sorry. RH Ashworth Hospital. It's what?
Ashworth Hospital.
Yes, volume 29. Tab 18, Julie.
What's the proposition that emerges from that?
The proposition from that is that with a more intensive review, perhaps it's as to for the court to look determining for itself what harm the policy may cause. Again, it may be that that's nothing more than Munjaz itself subsequently identified. But there's no doubt we say.
So was it in your submission, was Munjaz a case where it was submitted that the policy itself gave rise to the harm, or that the policy, if not applied properly, would give rise to the harm?
In just let me try to go back to my notes. In Munjaz, it was argued that the policy gave rise to the harm, and the court found that it didn't give. Ultimately, having adopted this particular scrutiny test, it didn't for Mr. Munjaz give rise to that harm. But it set out the principles 27 to 29, Lord Bingham, and Lord Hope at paragraph 80 to 82 approached the issue by asking themselves whether it would give rise to real risk or real treatment, which was in the scope of the article. And yes, effectively, the court found that the policy wasn't in breach of Article 3, but that was how it was put there. So, although it's perhaps suggested that this argument collapses into one, we say there are discrete grounds for the court to examine the question of the lawfulness of the policy against either limb of the way we put it, and in particular with reference to the absence of the 345D analysis, rules-based analysis that's required. But because of the shortness of time, as everybody has said in their submissions, I would just invite the court to read our skeleton argument again in relation to the structure of the decision making, which is at 71 to 79, where we say that effectively no one decision maker, this is actually how these matters do come about, no one decision maker looks at the claimant's case as a whole and identifies whether in under 345B, 345C, 345D, or Articles 3 and 8, whether taking those matters and analysing them, whether or not the person could be sent to Rwanda without creating a real risk. And it's that failure to have a holistic analysis which creates the risk. And we just remind the court that when we're looking at the policy, we have to look at the policy as a whole. That's, again, obviously uncontroversial and consistent with A. But looking at the policy and the practice as a whole, in terms of how it's applied, the two parts of the claims are quite clearly separated and effectively left the claimant sort of legal black hole, if you like. Those are our very short. I think I'm bang on time.
You are almost to the second, so thank you very much indeed. Well, now we'll rise in a moment. I think you're all aware, I hope that there was a little bit of canvassing that went on informally at the beginning of today, that we'd like to start tomorrow morning at 10:15 and on Thursday morning at 10:15. And I was about to add, so that we can all finish at 4:15. So it's not our offer to recoup some of the time that has been lost. Just before you get there, Mr. Gill. The other thing is, I noticed two new bundles arrived. I think they're yours, Mr.
Because one of you said the bundle had collapsed.
Oh, all right. That wasn't me then. So I think I'm okay. Yes, Mr. Gill, you wanted to. You're next in the morning.
Yes, my lord. I don't want to sound churlish at all about anything. The situation is what it is with the timing, but I just want to correct any impression. If it was, I heard somebody say that with the agreement of all the parties, that certain time had been extended this afternoon. Nobody asked us.
All right. Well, I can't remember if you've got 36 minutes, 29 minutes, or 30 minutes, but we look forward to hearing from you for about half an hour tomorrow. Lord Panic.
Nobody asked us about extensions of time. The applicant's side, appellant's side, were meant to finish this afternoon.
I do appreciate it.
We are where we are.
We are where we are, Lord
Nobody
Panic.
asked us.
No. Well, we don't want to take too much time finger pointing at this stage. We look forward to seeing you all in the morning.